your comments. Moderator's prerogative. So we did begin with the Fourth Amendment, but Peter mentioned several other kind of constitutional arguments that could be made. I'm going to turn it over to you, Paul, to think about some of these. So one, the First Amendment argument when it comes to imposing obligations on people who write code. Kind of void for vagueness or overbreadth. I also hear in that kind of a non-delegation separation of powers. So if, how would you walk through some of those constitutional challenges to, the broadness of the BSA, which, can be used by law enforcement and agency rule writers to cover whatever they want in kind of an arbitrary way?
Sure. So let me say something about at least one of those arguments, and then but actually try to bring it back to the Fourth Amendment, because I do think some of these, I do think the basic issue here is it's not exclusively a Fourth Amendment issue, but sort of at bottom, that's the provision of the Constitution where it seems like something fundamentally wrong is going on here. But the one doctrine that definitely seems, potentially very ripe for application to the BSA, particularly if the administration wants to kind of not go to Congress and try to really kind of retrofit that statute for crypto, and not just, sort of the first generation, but as it's evolved. That seems to fly right in the face of this so-called major questions doctrine that the court has developed over the last few years. And, I say this sort of guardedly because, as somebody who gets contacted to challenge a lot of administrative rulemakings as potentially in violation of the APA or something else, there is this phenomenon right now where, I don't know if anybody remembers that, Bruce Willis movie, The Sixth Sense, where the young kid saw ghosts everywhere, and people are seeing major question doctrine issues everywhere. Everything's a major questions doctrine, but this is like a classic major questions doctrine for an administration to have some big issue that Congress really should be dealing with and retrofit a statute that's been around for 40 or 50 years to sort of fit the new phenomenon. That is classic major questions doctrine material, also in some SEC issues, but we can talk about those some other time. So back to the Fourth Amendment, though. Here's to me what kind of unifies this and gets it back to the Fourth Amendment. To the extent there is this third-party doctrine, and to the extent you want to say anything nice about it, and that's not really my role, but if you want to say anything nice about it, it's designed to deal with a situation where the information in the hands of the third party is entirely organic, where it's just this is the way this technology works. Nobody started with how can the government get more information and then ended up with you don't have any Fourth Amendment rights. It's the telephone evolved, and then in order to get somebody on the other end of the telephone line, you had to push some buttons. And so, the telephone company had to have that information to connect you to the party on the other end of the line, and then they keep that information, and then the government gets it. But what you have in, the idea that a software developer would have to essentially completely artificially restructure themselves to become more like a traditional bank and keep a whole bunch of information that they have no organic reason to have just so they can turn it over to the government. I mean, I'll grant you that there's a species of a First Amendment compelled speech argument there, but at bottom, I think that's just a classic Fourth Amendment problem too. It's like the government can't sort of start with the idea that we don't want to comply with the warrant requirement and then sort of regulate with that end in mind and create a situation where we're, just the most cartoonish example is, as a prerequisite to doing a banking transaction, if the government makes the bank, makes me disclose everybody I've met with in the last 24 hours, that's absurd. I mean, of course I have a reasonable expectation of privacy in that, and it has nothing to do with the banking transaction. So the government can't sort of reverse engineer this to deprive us of our privacy rights.
And that's, in some ways, the heart of the Carpenter holding, too. People don't realize they're trading off their entire geographic movement history when they open their cell phone. And the court said that can't be outside of your reasonable expectation of privacy. Just because you wanted to use a phone, you no longer have a private location.